Good morning and welcome to the David and David on Real Estate podcast. And we have a very special guest with us today, somebody who has a lot of experience with litigation. We have Jake Newton joining us this morning. Good morning, Jake, and welcome to the David and David on Real Estate podcast.
Good morning. Thanks for having me.
It's great to have you on, Jake, because there's many times we've had episodes on podcasts we're talking about, real estate deals gone bad and certain issues that come up, and then you eventually got to go to litigation. And I'm not sure whatever I comment on litigation and what happens in that process that David ever believes what I'm really telling him. So we figured we better get a litigation lawyer on here so you can justify that some of the stuff I've been telling him over the years is actually true, and that's what happens when you're in the pits doing the litigation. But you guys have to be some of the busiest lawyers around right now because there's so many real estate deals going bad, right?
I think we're always busy. I think whatever the market is doing, there's always different kinds of litigation that arises because of the market. If it's rising, there's litigation. If it's falling, there's litigation. It's always busy.
You're just representing different sides of the complaining process, right? Like if the market's rising, then a lot of the times it's the buyers who are litigating because they want a better deal. The market's falling, a lot of the times it's the sellers litigating because they feel like they have a transaction that needs to close.
Yeah, that's exactly right.
Yeah. Awesome. Well, let's jump into some of the issues. So, what do you see happening right now today? What are some of the major trends happening in litigation?
So definitely the biggest trend I see right now are pre-construction condo purchasers who are defaulting. I'm sure that's no news to you guys. And so I guess, I don't know, maybe the last 20, 25, even 30 years, we've seen a lot of pre-construction condo purchasers, especially in Toronto, but also in the GTA, buying pre-construction condos, I guess holding the paper, holding the contract for 3, 4 years until it's built, and then making a gain of maybe $100,000, sometimes $200,000, flipping paper, signing the contract, and making a good buck. And it seems like the musical chairs has stopped. A lot of the defaults that I'm seeing are caused by, I guess, a lot of the purchasers that I'm seeing that are defaulting are individuals who are not buying their primary home. They're not buying their first home. They're already existing homeowners, and they're buying an investment property or two or four, because that worked. It was risky, but it worked for the last number of years. And now, because of interest rates and the value of these properties, their values are much lower or significantly lower than what their contract price is. And so when it comes time to get financing from the bank, because they don't have the cash to close, they need financing, the bank gets an appraisal and it comes in far lower than the value of the contract. And so they're not being offered financing anywhere near to what they need in order to close.
Right. So we have another situation where the market's falling, and that's the corporate of the property not appraising, the price not being justifiable, and the buyers are getting themselves into a little bit of trouble out there.
Yeah, that's right. And I guess there's some misconceptions. A lot of people call me and they say, I'm just considering walking away, but it's not always that simple. They think they can just walk away from their deposit, but a lot of these developers and builders are commencing litigation not only to recover their deposits, but also to recover the loss in the difference in the sale price when they eventually sell that unit to somebody else.
Yeah. So are you? I know we get it at my end before you get it sometimes when those buyers say, just ask the builder to reduce the purchase price because it's not fair market value at the time of closing. It's gone down. Like in general, when you even try and approach a builder that way, what's the response you're getting?
To start, maybe a year ago or maybe a year and a half ago when this really started, the answer was always no. I think some builders are coming around to the idea because what's happening is all of these builders they still own maybe a dozen or 2 dozen or 50 units in their buildings. And when you own that many units and you're trying to sell them, they're not going to put them all on the market at the same time. It's going to deflate all of them at once if they do that, obviously. And so they're realizing that maybe it's better. They want people closing. They want people in there. I think the smart ones at least do. And so sometimes giving some sort of leeway, whether it's knock down the price by a little bit. I think that's the prudent move. And sometimes even if you can retain a deposit and then sue, there's not always something you can get from some of these purchasers, right? You still, even if you get a judgment, 2, 3, 4 years down the line, people don't always realize that you still actually have to go and collect that judgment. And so if those individuals are going to go into bankruptcy, or there's mortgagees that will be ahead of the builder, you have to kind of think. So I think the prudent builders are working in good faith to see what they can do with these, defaulters, these purchasers, because I think that the smart ones realize the alternative is even worse for the developers.
Jake, that's an important consideration. Instead of commencing litigation, there's another process of negotiations or conversations, where at all costs, you're really trying to avoid, going through a lengthy court procedure and, rack out a whole bunch of hours and fees and a prolonged, lengthy litigation process.
Yeah, that's right. I mean, litigation, it's super stressful. Some developers and builders, they're used to it, or they have maybe in-house counsel who can work directly with the litigators. But I think the experienced ones know that it may not be worth it, especially if they're looking at 50, 60 units in their building. And so, I see quite a number of extensions. I've seen, I think, one instance where the building was offering financing, almost kind of vendor take back mortgages in that way. So there's some unique ways to get around it, but it's really an issue that's facing a lot of builders these days. And I see more on the outskirts, maybe of the city, more outside, in the GTA as opposed to the city proper. It's a bigger problem because I'm seeing a higher discrepancy in the contract price versus the valuations.
Yeah, I was going to say that, on the outskirts of the city, what we've seen happen in the last 3 to 4 years is, prices have really jumped. And the issue is that, construction prices are similar. Like whether you build a condo in Toronto, or whether you're building a condo in Kitchener-Waterloo, the price of drywall is the same, right? It doesn't change. So the cost per square foot wasn't really differentiating much from some of these projects. And I think you nailed the nail on the head is that on the outskirts, we've seen prices appreciate at a significantly faster rate. But the problem is, you have a $400,000 condo, or you have a $400,000 detached house selling in the resale market, and buyers are scratching their head saying, okay, why am I going to close on this condominium when I can get a detached house for the same price in some of those suburban neighborhoods right now?
Yeah, that's exactly right. And this is more your area of expertise than mine. But I think what you're alluding to is that the price of houses have it's a bit of a weird market for houses, I think, but it's kind of stagnated, or maybe even it's going up a little bit. I don't really see it dropping in the same way as condos. Maybe you can tell me if you think I'm wrong. But I do see that house prices stabilized, and I agree that the discrepancy is really growing between the condo market and the housing market. They're not working in tandem with one another. I mean, do you agree with what you're seeing?
Yeah, no, absolutely. I think condos have really risen, right? Because I think the first-time home buyers have, there's the most sort of room for appreciation there, right? But now detached houses have rescinded back a little bit, but condo markets have really fell back, right? And it's the whole investor client is just not present in today's condo market, and that's where a lot of the issues on valuation are coming back at.
And do you see that changing in the foreseeable
I do. I mean, as prices start going backwards and as the numbers start making sense, where properties are cash flow positive, I think we're going to start seeing the investors sort of jump back into the market saying, you know what, at these price points, the numbers make sense. The problem is that, you know, the condo market, you only have one source of income. You have one tenant. So it's a lot harder to make those numbers make sense as opposed to, you know, a fourplex or a duplex or doing some of the other investment activities.
Yeah, fair enough.
Yeah.
What we're finding in closings, the builders, I don't think I've come across a builder that really wants to reduce their price in order to get something closed. They're being flexible with extensions, a little more reasonable with like give them some rope to see if they can really find a way to get it done, but they want to hold their prices. They're a little more flexible about giving a buyer the right to assign if they can find someone to assign to. The issue these days is because of the declining value, we're doing assignments for a loss instead of assignments for a profit, right? Which is different. And I'm still surprised by the indignation of some of the buyers, the defaulting buyers that just can't understand why the builder won't reduce their purchase price. Like it's not, the value's not there, you know. And I say to them, if the price went up over that 3-year period, would you be offering to share the profit with the builder? If you were going to assign this and flip it and make a profit, were you going to share that profit with the builder, other than the builder's going to take their pound of flesh on a stupid assignment fee? But no, right? Like they have to understand, Jake, that like it's a contract, right? They've agreed to buy this property at a price. They're bound by it. And if they default, that's where you come in. There's consequence, and you're trying to save them some money. And it's a question of how much can you potentially negotiate and save or deal with the facts to see if you can save them some of the damages. But they're responsible for damages, right?
I agree. And that's what I was kind of touching at before when I talked about it being not first-time home buyers who are defaulting here, not people buying their primary home, but investors. And I think you nailed it, David Korman, that a lot of these defaulting purchasers, you know, they're not willing to take any responsibility for a situation where they were maybe a little bit greedy. And I'm not, you know, saying anything derogatory about them. I just think that everyone is a big boy or big girl. When you buy real estate, you know, you have to understand that there's consequences. The market goes up, the market goes down. And if the market goes down, that is not a reason or an excuse rather that not to close.
Yeah. And Jake, if people are using that as an excuse, they're getting penalized very heavily by the court systems. Maybe we can kind of talk about, you know, some of the decisions that are coming down, because I think, you know, we saw this kind of happening through COVID where people were like, oh, you know what, the prices are too expensive. I overpaid, can't afford this mortgage. I'm just not going to close, right? I'm going to walk away. So what are you seeing in terms of the court rulings coming down from some of those decisions?
Yeah, so early on in COVID, we saw a lot of that. And I guess litigators were attempting two major arguments that both didn't work. They were arguing that there's, the application of force majeure and the application of the doctrine of frustration. And the courts, basically ruled against both of those arguments on a general, term. Obviously, there's some situations where it does apply. The courts have held that you need a force majeure clause. And a lot of these standard form, ORIA forms don't have force majeure clauses that specifically touch on, the issues that arose in COVID, or
Can you
even
maybe explain what that means to our listeners really quickly?
a force majeure clause, raises that if there is certain circumstances that the parties didn't account for at the time that they contracted, that there's a way for the parties to either pause the completion of the contract or get out of it entirely. And so the common ones are acts of God, a flood, earthquake. Some of those, all of those clauses that are drafted now say COVID-19 and pandemics. They didn't all necessarily say it at the time, but the courts have held that there is not a common law right to force majeure. It actually has to be stipulated in the contract for application. And in a lot of circumstances, it doesn't actually stop the contract. It just will pause the contract until the point in time that the force majeure event has been completed or ends.
Yeah, and that's a key point. I guess we throw strikes in there too, because if you're drafting one, you want to include strikes in that clause. But that just creates like an extension or a right for an extension as opposed to a right to terminate the contract in most cases, right, Jake?
Yeah, that's correct. And then the other doctrine is frustration, which is, I guess, similar. That's more of the common law, where you don't need it specifically to have a clause which says a frustrated contract would be paused or terminated. But frustration, I think I pulled the actual case law on what frustration is in case we wanted to discuss it. And it's the principle of frustration of contract arises where an unforeseeable event occurring after the formation of a contract renders the contract unable to be performed, but not where the event was the result of a voluntary act of the party seeking to rely on the doctrine. And then it goes on to say, it renders the APS different from what was undertaken by the contract, I guess by the contractor. So the courts have not really permitted that argument either. They're not suggesting that it is a thing radically different, that the market is dropped, or in other situations if it rose, that wasn't contemplated by the parties. That's not something that the parties could not have contemplated.
And that makes sense because we're talking about regular everyday market factors. Like it's a well-known fact that the market goes up, that goes down, that is sometimes it's a little slower, sometimes it's a little faster. And in my opinion, when you look at the definition of frustration, you apply some common law principles to it. That's nothing out of the ordinary.
I agree. I don't know if all of these defaulting purchasers agree with you or understand what you're saying, but I think you're certainly correct.
Right. And maybe just touch, because I know we're going to have you back on in more episodes so we can discuss a couple actual cases, but maybe just talk for a minute about the concept of damages, because a lot of buyers think, okay, if I can't close, I'm going to walk away from my deposit, and that's the end of it. But that's not the end of it, right? That's not their exposure. So maybe just explain that, Jake.
Yeah, I think that's a huge misconception that I got a lot of calls from people telling me, I don't think I can close. Is there anything I can use to get out of this contract? And if not, worst case scenario, I'm just going to walk away from my deposit. And sometimes it's 60,000, 100,000, a bit more. But yeah, you're right, David, that's not the case. And so a defaulting purchaser, if the contract is terminated as a result of their breach, results in there's kind of two streams to it. Their deposit is forfeited. So let's say it's $100,000 deposit. It's forfeited to the vendor. And then the vendor then has to resell the property. And so if they resell it for a $200,000 loss, they can then claim the $200,000 in damages from the purchaser. Now that $200,000 would be offset by the deposit. However, it gets a little complicated. I guess if the loss and the resale was $80,000 rather, the $100,000 wouldn't be reduced. The deposit wouldn't be reduced to $80,000. The deposit's forfeited entirely, and then it's only the surplus that would amount to the damages. But on top of that, the other damages that I plead, or what I'm seeing also against these defaulting purchasers, are carrying costs. If it's not a builder, even a builder, but individual purchasers where, or rather individual vendors where the purchaser defaults, they might be carrying two properties where they have to get second mortgages in order to carry property that they had originally sold. And there's other kind of associated costs that are, I classify as carrying costs that would add to the damages as well.
Yeah, and that would include stuff like insuring both properties, obviously paying mortgages and lines of credit that are registered, the ongoing utilities, property taxes, right? So ultimately a buyer's responsible for real damages that a non-defaulting seller would incur. And then there's some equitable principles that you guys argue in court with the judge about whether the deposit that's being forfeited should cover all that, or whether they should get damages in addition to that deposit, right?
Yeah, I'm not sure if it's an equitable argument. It's more so just that the deposit is forfeited, and any damages beyond the deposit, if your damages are below the deposit, then the damages would be capped. You wouldn't owe something beyond what your deposit already covers. But you would set off the damages by the deposit. It's not forfeited without any application or set off against your total damages.
But any buyer should know, like, they have no entitlement to get their deposit back at all. Like, it's forfeited. Goodbye, right? And if they get lucky, they might get some of it back because they retained you, and you can make a good argument in court.
If they breach and they're found to have breached, their deposit's gone.
Right.
Even
Not
if
getting
it's
it back.
excessive, Jake, like sometimes we're seeing like these $200,000-$300,000 deposits. Like, what if the damages are 50,000, deposit is 300,000? Like, is the whole 300,000 deposit gone?
In theory, yes. You're entitled to the forfeiture of the deposit. I've seen some people try to argue, relief from forfeiture. But I think on a general basis, you should consider and act on the basis that your deposit's forfeited.
Awesome. Well, David, that actually brings together a lot of the things that we always talk about. We always encourage people to put down large deposit as a deterrent, to make sure that the transaction proceeds smoothly. And, I think that now more than ever, that's going to be a really key consideration putting deals together, not only to put them together at the beginning, but more importantly, to make sure that come closing date, that they actually close. And this is something that we've been advocating since our very first podcast episode.
I mean,
Yeah.
just to jump in, I'm not sure that it's such a, that people should avoid putting down big deposits if that's what they need in order to, get a deal signed, especially in the resale market as opposed to the pre-construction market. But I think what purchasers should consider is, if the value of the property that I'm selling in order to be able to buy this property on the closing date were to decrease in value, or the property that I'm going to purchase were to decrease in value, could I still get financing? Could I still complete the purchase? Maybe to give themselves a little bit more of a gap instead of buying right at the top of what they could afford, or even beyond what they could afford, with the presumption built in that they think that the market will improve between the time that they sign the contract and the time of closing.
Yeah, lots of things to consider. But the biggest thing is make sure you avoid court at the end of the day.
I agree.
Jake, thank you so much for coming on this podcast. We're going to have you back next time when we jump back into the topic of litigation, and we're going to dive a little bit deeper and peel back more layers. So thanks so much for joining us today, and join us next time as we continue our conversation with Jake Newton and dive deeper into litigation.
Awesome. Thanks for having me.
Thanks, Jake.
Thank you so much.